Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at defences in negligence. Up until now, we've focused on building a negligence claim. We've looked at duty of care, breach of duty, causation, and damage. But what happens when the claimant successfully proves all of those elements? Does the defendant automatically lose? Well, the answer is not necessarily. The defendant may still have a defence. And for SQE purposes, there are three key defences you need to know: consent, contributory negligence, and illegality. The easiest way to understand them is to split them into two groups. Some defences completely defeat the claim. Others simply reduce the amount of damages. Let's start at that point. So the big distinction, and the first thing that I want you to remember is this: consent and illegality are generally complete defences. If they succeed, the claimant recovers nothing. Contributory negligence is different. It's a partial defence. The claimant still wins, but receives less compensation. The SQE questions always start by asking, does this defence eliminate liability altogether, or does it merely reduce damages? That distinction alone, it tends to be worth marks. So defence one is consent, and you'll often see the Latin phrase volenti non fit injuria, which roughly translates as no injury is done to someone who consents. The basic idea is really simple. If the claimant fully understands the risk and freely agrees to accept it, they may be prevented from recovering damages. However, students often think this defence is much easier to establish than it actually is. In reality, courts are very reluctant to find consent. The defendant must therefore prove two things. Firstly, the claimant knew the nature and extent of the risk. Secondly, the claimant voluntarily agreed to accept that risk. And those two things are very different. So the next thing to consider here is knowledge is not consent. And this is one of the most important principles in this topic. A claimant can know that a risk exists without agreeing to accept it. Imagine getting into a car with someone who's been drinking. You may recognize that there is some risk. That alone does not necessarily mean you consented to being injured through the driver's negligence. And this is where many defendants fail. They can prove the claimant knew about the danger, but they cannot prove that the claimant willingly accepted the legal risk of injury. For SQE purposes, knowing about risk is only half the battle. The defendant must show actual acceptance of that risk. So when does consent succeed? Well, consent succeeds only in fairly exceptional circumstances. The classic example is where the risk is so obvious and so extreme that agreeing to continue amounts to accepting the consequences. Think of someone knowingly getting into a light aircraft flown by an obviously intoxicated pilot. In that situation, a court may conclude that the claimant truly accepted the risk being created. But remember, courts generally interpret consent very narrowly. As a practical matter, it is much easier for a defendant to argue contributory negligence than consent. Let's quickly just look at consent and employees, because consent is particularly important in employment cases. So employees rarely have complete freedom to refuse workplace tasks. They may face economic pressure, managerial pressure, or concern about losing their employment. For that reason, courts are reluctant to conclude that workers genuinely consented to workplace risks. Simply continuing to work, despite knowing a danger exists, does not usually amount to consent. The employee may have recognized the danger. This does not mean they agreed to be injured by it. The same principle applies to rescuers. If someone rushes to help another person following the defendant's negligence, courts generally view them as acting under moral, social, or legal pressure. The rescuer is not choosing danger for pleasure. They are responding to an emergency. And as a result, consent is rarely available against rescuers. This reflects a wider policy choice. The law wants to encourage rescue, not punish it. So a second defence to consider is contributory negligence. And this is not a complete defence. The claimant still succeeds, however, damages are reduced. And the key question is, did the claimant fail to take reasonable care for their own safety? And there are two elements. First, the claimant was careless. Second, that carelessness contributed to the damage suffered. Notice something important. The claimant does not need to contribute to the accident itself. It is enough that they contributed to the injury, and that distinction matters. Now, the easiest illustration here is a seatbelt case. So imagine a defendant causes a road traffic accident. The claimant did nothing to cause the collision. The accident is entirely the defendant's fault. However, the claimant was not wearing a seatbelt. If the injuries would have been reduced by wearing one, the claimant's damages may be reduced. Why? Well, because the claimant helped cause the injury, even if they did not help cause the accident. Students regularly miss this point. The focus is not who caused the accident, the focus is who caused the damage. Now, how much damage is reduced? Well, the court looks at what is just and equitable. And two factors are particularly important. First, culpability. So how blameworthy was each party? Second, our old friend causation. How much did each party contribute to the loss? The claimant then applies an appropriate reduction. So the claimant still recovers compensation. Their amount of compensation is though reduced, so they do not receive the full amount. Special claimants. The reasonable person standard would apply here too. However, courts recognise that some claimants require special treatment, for example, children. A child is judged against the standard expected of a reasonable child of a similar age, and the court asks, would an ordinary child of that age have acted differently? The same approach appears for rescuers. Rescuers are judged as reasonable rescuers. Courts understand that emergency situations force people to make split-second decisions. A rescuer will not usually be found contributory negligent simply because, with perfect hindsight, a safer option existed. The law recognises the reality of emergencies. The same principle appears in what are known as dilemma cases. So where the defendant's negligence creates a danger situation, the claimant is not expected to make a perfect decision under pressure. The question is whether the claimant's response was reasonable in the circumstances, not whether it was the best possible response. The third defence to consider is illegality. And you'll sometimes see the Latin phrase ex turpi causa non oritur actio, which roughly means no action arises from a disgraceful cause. Again, this is generally a complete defence. If successful, the claimant recovers nothing. And the basic idea is that the courts will not assist the claimant whose injury arises directly from their involvement in serious unlawful conduct. So when does illegality apply? Well, the key point is that there must be a close connection between the illegal conduct and the injury suffered. And that connection is crucial. Imagine two burglars breaking into a house. One carelessly injures the other while carrying out the burglary. The injured burglar is unlikely to receive compensation. The injury arises directly from the criminal enterprise. The courts are unlikely to assist. However, not every illegal act triggers the defence. Imagine a motorist parks illegally. Later, somebody negligently crashes into the parked vehicle. The parking offence has little connection to the accident, and the claim will therefore usually continue. So for SQE purposes, always ask, is the claimant's injury closely connected to the illegal activity? The answer is no, the defence is unlikely to succeed. Excluding liability. This has to be our final point. Sometimes defendants attempt to exclude liability using notices or disclaimers. You'll notice this again in topics such as pure economic loss and later on when we get to occupier's liability. For now, simply remember that exclusion clauses are heavily controlled by law and do not automatically protect defendants. Just because a notice says no liability is accepted does not mean that that notice will actually be effective. So what's Bowdie's bottom line? Well, defences are much easier if you remember one simple distinction. Complete defences are consent and illegality. If successful, the claimant gets nothing. Partial defence is contributory negligence. The claimant still wins, but damages are reduced. When analysing any question, ask, did the claimant knowingly and voluntarily accept the risk? If yes, think consent. Did the claimant fail to take reasonable care for their own safety? If yes, think contributory negligence. Did the injury arise directly from serious illegal conduct? If yes, think illegality. If you can make those three decisions, you'll have most negligence defence questions under control. Thanks for watching this Bowdie short. Look out for more videos in the series.